What are we seeing? All persons have made things to before the honorable. The justices of the appeal now sitting at Boston within and for the Commonwealth. Now, give your sin and you shall be heard. Now, say the Commonwealth of Massachusetts, this court is open to be seated.
Thank you. Good morning, everybody, and welcome. Happy New Year. Welcome to the appeals court session in courtroom 4 for Monday, January 9th, 2023. Your panel for today is me. I'm Greg Massing. On my right is Justice Peter Sachs, and joining us remotely is Justice Maureen Walsh. The reason that Justice Walsh is joining us remotely is because of COVID protocols. This is sort of a last minute unusual situation. Hopefully that won't be necessary next week. So for those of you who haven't been here before, the rules are simple: 15 minutes per side, no rebuttal. We have all read your briefs, and we're up on the facts, so you can jump right into your arguments. You're free to use all 15 minutes, but there's no penalty for finishing early. The two of us and Justice Walsh have your materials on our tablets here. So if you see us looking away from you and looking at our tablets, we are not reading the New York Times or searching the web. We are looking at the case materials, or we're trying to figure out how to turn off the camera that we just turned on accidentally. So with that, I'll call the first case, which is Commonwealth versus Stroop, 2022 P168.
Good morning. Tracy Green for the appellant, Mr. Stroop. This case involves a probation surrender that happened in the Fall River District Court, and it involved 2 new arrests. And my argument is that non-reliable hearsay came in during the course of the probation surrender with regards to both of the arrests. Defense counsel did object to all of the hearsay that came in during the course of the surrender. I would just start my argument with the arrests that involved the burglary at the motel. Can I
ask a question at the outset that might simplify things? On the drug charge.
Yes.
Has that been resolved?
It has. The defendant he pled guilty. He received a 90-day house of correction sentence that he served concurrent with the 2.5 years sentence that he received on this probation surrender. I would argue that that doesn't actually mean that his rights to appeal are null and void or moot at this point.
Does it moot the challenge to the factual basis for the probation violation finding on that issue, on that offense?
I believe that Commonwealth versus Pena at 462 Mass 183, 2012 indicates that a guilty plea does not render the underlying revocation moot. So I would say no.
The revocation, not the Justice Sachs asked about the factual basis for that violation. There's Pena makes a distinction between the factual basis, the finding of the violation, and then the subsequent sentencing.
Mm-hmm. I think that with regards to the revocation, I mean, it's based on the facts. So I would just argue that they're interrelated and that you can't distinguish between the two.
No, of course, no, of course you can. You argue in your brief that you can. You argue in your brief that because you're not sure what the revocation was based on, we should remand it. But it's clear now that your client admitted to the drug charges. So it's clear that that was reliable.
Okay.
Right.
Well, but with regards to the burglary at the motel, that case was actually dismissed for want of prosecution. So I would argue that that's still a live issue before the court and it's not moot. With regards to the probation surrender, that it did involve the burglary at the hotel, I'm arguing that I do agree with the Commonwealth that Officer Fakan did make his own independent observations that a burglary occurred, and based on the damage to the hotel room as well as the video that was taken of the burglary itself. However, what I am arguing is that the statements from Miss Estrella that came in through Officer Fakan, where she identified the defendant as being Mr. BREON Stroop, were not reliable pursuant to the factors set out in Commonwealth versus Hartford. Her statements essentially all went to the identification of the defendant during the course of the surrender. Specifically, she was the one who identified Mr. BREON Stroop in the video of the burglary. She was the one who identified Mr. BREON Stroop as the owner of a telephone that was observed at the scene of the crime, due to the fact that she indicated that it was his son that was on the phone. She identified the defendant on a Snapchat video that was, she indicated that she took with the defendant that same day. She also, so it's in essence, all of the identification evidence came in through, from her, through Officer Vacan at the hearing. And I'm arguing that that was all non-reliable hearsay. And I'm arguing that that's non-reliable hearsay because the corroboration factor from Commonwealth versus Hartford was not met. When you actually consider what
Can I
Officer Vacan
ask,
testified.
just to be clear,
Yes.
is when we evaluate the reliability of those statements, do we evaluate them standing alone, or do we evaluate the reliability of the declarant overall based on the Hartfield factors? In other words, can we take into account that her statement that her motel room was broken into and her belongings were taken was corroborated by observations of the officer, for example?
I think you can take it as corroboration as to the fact that a burglary occurred, but with regards to the identification of the defendant, I don't think that the hearsay was reliable because she identified the defendant on a video that the way Officer Vacan testified, or excuse me, at the trial, excuse me, at the probation surrender, he said he described the video as being black and white. He indicated all he could see was 3 male figures. He indicated he could not see their identity. He couldn't make out an article of their clothing. The only description that he could make out from that video was that one individual had light clothing on, another individual had dark clothing on, and the third he couldn't make out at all. And so it was based on that video that she determined that the individual at the scene who committed this crime was in fact Mr. BREON Stroop. And so I would argue that given the fact that how Officer Vacan testified the quality of this tape and how she immediately jumped to the conclusion that it was Mr. BREON Stroop and that he would never actually adopt her identification of the defendant during the course of the hearing. He was very careful to always just say, all he would say was when he saw the Snapchat video that was taken of the defendant the same day with Miss Estrella, he indicated that he agreed that the clothes were similar and that they were both light, which essentially describes a million different people.
Who's the he? Are you talking about the officer? Who's the he you're referring to here?
I'm sorry?
You're saying he.
I mean, the officer.
The officer.
Vacan. Yes,
Okay.
he was. Yes, he testified at the hearing. And with regards to that, specifically from transcript 1, pages 14 to 15, I think it really illustrates the fact that he would not go so far as to actually identify Mr. BREON Stroop on this video. And he was very careful.
He can't do it because he doesn't know. All he knows is what Mr. Stroop looks like from the RMV photo or perhaps the Snapchat photo. All he could do is say, same person here is there. But she has observed him previously, and she knew what clothes he was wearing. And she is arguably in a better position to make an identification.
I think she can make an identification that she knows Mr. BREON Stroop, but making the leap between knowing him and actually identifying him on the video of the burglary based on how poor the video was, according to Officer Vacan, which no one else was ever able to see, that was taped over. So defense counsel never even had the opportunity to view this. Based on his description of the video itself, it was extremely vague. And he, even after he was shown the Snapchat video with Mr. BREON Stroop on it, and the he also the RMV photograph that you talked about, he never once said during the course of this hearing, he never made the connection and said, based on the RMV photo, based on the Snapchat video, I find that the person on that video is in fact Mr. BREON Stroop. And with regards to his actual testimony, he was asked, Officer Vacan was asked, what did you observe on the Snapchat video? Officer Vacan responded, I observed it appeared to be similar. It was light colored clothing with like a dark stripe on it. Officer Vacan was asked, what did you see the victim who identified Mr. Stroop doing in that video, meaning the burglary video? And Officer Khan responded, the male that she identified, meaning Miss Estrella, to be the defendant carry clothes. He never actually adopted her identification of Mr. BREON Stroop as being on that video. He would only go so far as to say that he agreed.
Maybe
that
he
the
didn't
clothes
have
were both-
personal knowledge, so he was being appropriately cautious because he didn't have personal knowledge. All he was doing was relating what he had observed her do and what he had heard her say.
I agree he was relaying what she said, but whether or not what she believes is actually reliable, given how vague this video was, and he was shown the RMV video, the RMV picture, he was shown the Snapchat, and he actually saw this video, and he would not jump to that conclusion. Yet the judge during the course of the hearing found that her identification of the defendant was in fact reliable, yet he is the witness who observed the two never actually made that connection. And this is the only way to identify Mr. BREON Stroop as being at the scene because there's no percipient witnesses and there's no other evidence aside from this one video. So I think that he was very careful with his testimony. I think he would only take it so far. And I would argue that this is similar to Commonwealth versus Ortiz, where at a probation surrender, the police officer testified as to statements that was given to him from the victim, and the court determined that these statements were not in fact reliable. And what happened was the victim had told him that her car was hit by her husband the day before, as well as he also used a bat and hit the car the day before. And the officer went out to the car. He observed that there was damage to the car. And at the hearing, he said, I did observe the damage, but I can't say that I thought it was fresh. So again, it's like he's adopting a part of what she said, but he wouldn't go so far as to actually say that the evidence that she is saying actually matched what he saw. And I would argue that that is directly analogous to this case, where he only would go so far as to say that the individual in the Snapchat video had light clothing on, and the individual on the burglary video also had light clothing on. These are just general descriptions that can meet a
What
million
about the
different
phone?
people.
Does that tend to corroborate her identification of him on the video?
Well, I would argue that it's so general, no, and that it doesn't meet the standard of Commonwealth versus Ortiz, which that's what they said. It can't just be this one just general piece of information is sufficient to find her statements to be
We
reliable.
have two
so
here,
that-
don't we? I mean, she says that's him on the video and that's his phone that was found outside my motel room.
And I
Well-
was with him in my motel room earlier tonight, or he was with me.
Right. Well, with regards to essentially whether or not the information that she gave to him was in fact reliable and credible, I mean, Officer Vacan never said that he actually knew her from any other time. She has $10,000 of cash in her room. She claims she doesn't trust banks. She doesn't say where this money came from. She indicates the defendant was in her room for a period of time. She showed him this money. She takes him home. She never actually even reported this burglary to the police. It was reported by an unknown person.
Well, I mean, isn't the evidence that she just came back to learn about it? Like she was out and she came back?
It was actually never really clear. It
Okay.
just said an unnamed person reported it, and then she just kind of showed up. I don't really understand, but she was not the one who called the police.
Okay. Can I ask
And
you,
she
I'm gonna
identified-
I'm just sorry. I think I understand what your point. Justice Walsh, are you able to hear us, and do you have any questions at this?
No, I can hear you loud and clear, and counsel has answered my questions.
Okay. So we'll do our best to, you're over to the left of us here, and so we'll do our best to but jump in if you need to.
Thank you.
Just the last point that I would just make with regards to her credibility is, as far as the phone is concerned, is that Officer Fakan, when he was asked about how she was able to identify that the defendant's son was on this picture, given the fact that she had just met him that afternoon, even he said he had no idea. So I do think that maybe he had some questions about her credibility as well, which is perhaps also another reason why he didn't adopt her identification of the defendant as being on the video.
I mean, if he had adopted her identification, you'd
I
be
don't
here
think
arguing,
he
you'd be
never
here
actually
arguing,
did.
you'd be, if he had, you'd be arguing that he had no basis to. right?
Well, I think the fact that he's the one who viewed this video and he didn't make that conclusion. And so I think given the fact that nobody else can ever watch this video, the defense attorney never got to see it, we really have to look very carefully as to what he was able to, or what he was willing to say. And that all he was willing to say is that the clothes are both light colored. And I think that was a very clear and very deliberate statement that he made. He would never actually say that he agreed with Ms. Estrella that the defendant was in fact on this burglary video. And in fact, like as from the statement that I gave you, he literally said, Ms. Estrella was the one who identified the individual in the video carrying the clothes. He would never adopt it. And I just think
Counsel,
it's,
let me interrupt for one moment. Let's pretend for a moment we don't have the officer's testimony at all. Just for a moment.
okay.
So you've got evidence that she knows him, that she was with him that day, that she describes the type of clothing, that his phone was outside of the hotel, and that she identifies him. That's not reliable hearsay? Because you're getting hung up, I think, on the fact that
So
the officer
Are you saying
didn't.
like if they just went forward on the police report, like without his
Yeah,
testimony?
right. You're getting hung up on the fact that this officer wasn't comfortable identifying this very poor quality video. So
I
take
guess
the
I am-
officer out of the picture, take the paperwork, the police report, and what would you say to the reliability factor of those? She knows him, she was with him that day, she described the at least coloring of his clothing as to being, she describes that that's him in the video, and his phone with his picture with him and his kids is found outside, and she identifies him through that.
Well, the phone was just of his son. So his
Son.
face
Sorry,
was not
so
actually
child.
on the phone.
Oh, okay, so
But with regard, I
you
guess
would
my,
challenge the reliability of that hearsay if it was brought in a paper form, such as a police report? I'm just asking.
I would say no, Your Honor, because I don't know how the judge can determine what the reliability is with regards to this video, which the only point upon which they were actually able to identify the defendant as being at the scene was on this video. And so without Officer Furkan's testimony, at least with regards to the quality of this video and whether or not you can actually connect the defendant, I think that best all we can assume is that Ms. Estrella assumed that he was the one who committed the crime because she saw him earlier that day and he saw the money. So I think she jumped to a conclusion, she made an assumption, and Officer Furkan, who did watch the video, would not draw the same conclusion, knowing all the same information that she did from her.
Right.
Okay.
So I'm asking you in your analysis is to take Officer Furkan out of the equation to see if her testimony standing on its own could be
Well-
determined reliable.
Without Officer Furkan's testimony, the court has absolutely no way to determine the credibility of Ms. Estrella or this video itself. So I would argue that it would be even weaker without him, but even with him, that
And with him, because he did not say, I believe that that's the defendant, Mr. Stroop. That's the
Exactly.
fatal error.
exactly, because he's the only one who watched that video. So if he can't make that conclusion, how can the judge? When the judge didn't have an opportunity to view this video because the video was erased. So the only witness who actually observed this video, who was at this hearing, was Officer Furkan.
Thank you.
Thank you. Thank you for your time.
Thank you, Attorney Green. We'll hear from the Commonwealth.
Thank you. Good morning. May it please the court. My name is Stephen Nato, Assistant District Attorney from the Bristol District on behalf of the Commonwealth. Our position, of course, is that the evidence that was hearsay at the revocation hearing was substantially reliable and admitted properly in the judge's discretion. I'll begin with the quality of Ms. Estrella's identification of the defendant as the person who broke into her hotel room. Contrasted with Ortiz, this is not a case where Officer Vachon simply merely repeated what Ms. Estrella told him. His testimony and the report submitted together kind of established a full kind of course of investigation, beginning even before he spoke to Miss Estrella with his own observations of a broken window and a door ajar at room 145.
But he can't corroborate her identification.
Well, there's no indication, obviously, that the officer himself ever saw the defendant with his own eyes or that he had any prior familiarity with the defendant. But the circumstances here do tend to corroborate that identification and establish its.
Well, I mean, how does it corroborate the identification? It corroborates that a break-in occurred. I mean, do we even know that there was really ever $10,000?
Well, no, that what was stolen, but it is clear that items were stolen. The officers saw that on the video himself. The plastic bin, the defendant with clothes in his hands as they fled into the car and then drove away. But I think, again, it's sort of the circumstances under which Ms. Estrella's identification of the defendant were made establish its reliability. The fact that she immediately on seeing the video was able to identify the defendant and Mr. Toure by name. The fact that she confirms those identifications when RMV photos are provided, that Officer Vachon can, again, the video's in black and white. Was not admitted. It was lost prior to the hearing. So the judge couldn't verify its quality, but the officer did say, I was able to at least compare that a Snapchat image of the defendant apparently from that same evening or early morning hours was consistent with what was depicted in the video. And as well, there's a phone here and she says, that's the defendant's and because I recognize that child to be his. So there's a basis for her connection and that she's demonstrates that level of familiarity, not just with his appearance, but who this child on the phone is related to, what the relation is there. Those circumstances together, and again, the fact that we have pretty compelling evidence that a break-in did in fact occur, establish the reliability, not just of her account of the events, but her identification of the defendant. And then, so again, that full report supplemented with the officer's testimony itself, I think established overall that the variety of sources of hearsay as to the break-in were substantially reliable and properly admitted.
Do you agree that the as far as the drug crime, that's moot? So there's the drug crime, the drug violation, that's moot, or that's he's agreed, he's pled guilty to that. There are those technical violations. If we disagree with you on the burglary at the motel, what is the remedy?
It would be, if it's just as to the break-in,
right.
I mean, that may have affected the judge's overall sentencing scheme. So I think even in that case, it would go back for kind of an overall dispositional review, in the same way that if both of the new charges were found to be based on unreliable evidence, it still goes back for the judge to decide whether technical violations on their own justify the sentence he imposed, whether he should, adjust that somehow, reprobate, do something else dispositionally. But I think in both circumstances, a remand is.
Does the 2.5 on the probation revocation, is that longer than the 1 year that he got on the concurrently on the subsequent drug crime, or does the drug crime go after the? Do you know?
To be honest, I'm not sure how those lined up in terms of timing and whether what he would have been eligible for in terms of release. But yeah, so that I don't know. I apologize. But unless there are any other questions as to the break-in itself, I'll turn briefly to the drug case. Obviously, the arresting officer here did not testify, but it was the arresting officer, the trooper's report. Everything in it was based on his own observations, his own conversation.
You don't want to argue that that's moot, that the guilty plea makes that moot?
It may be, and I'd be happy if it did. My understanding was that the defendant still had the right to hold us to our burden at that hearing. If we did not meet that burden, subsequent events executed the hearing would not have absolved us of that. I could be wrong on that. Happy for the panel to disagree, but
The
assuming
case you
that-
want to look at is Commonwealth versus Milo, M-I-L-O-T. It's 462 Mass 197 at 201 from
Sort of
2012.
A companion to the Pena case, which was where they say it's not moot as to the disposition.
Okay. Again, just briefly, the allegations contained in that police report, the observations contained in that police report were substantially reliable based on the level of detail, based on the defendant's own admissions to the nature of the substance. Although he suggested that he was cutting it with other substances, he did say, it's, I'm selling this bag of Coke to the guy in the rental car. Mr. Touré's statements tend to corroborate that. I don't know how that bag of Coke got there, suggesting he has some idea what the substance itself is. And again, the judge appropriately found that did not constitute an abuse of discretion, or that hearsay was reliable, excuse me. And again, fairly straightforward as to the drug case. If there are no other questions as to either of those issues, I would simply rest on the brief.
Justice Walsh? Okay,
No question,
thank you.
thank you.
Thank you very much. Interesting case. We'll take it under advisement. The next case that we'll hear will be Commonwealth versus Labbie, 21P919.
May it please the court. Joan Fund for Mr. Labbie, and good morning, your honors.
Morning.
The issues before the court, my client was convicted of assault and battery with a dangerous weapon and assault and battery on a household member. As I stated in my brief, and I believe conceded to by the Commonwealth, that there was insufficient evidence to hold the defendant or find the defendant guilty on the assault and battery dangerous weapon portion. The dangerous weapon was a door. And as the court understands as well, that there is a per se dangerous weapon, which a door is not, or there's the use of a dangerous weapon in a manner or in a reckless manner in which an object does become a dangerous weapon. In this case, the allegations regard a push. From the facts and looking at the transcripts, a push of the appellant towards the complaining
Counsel,
witness.
let me interrupt you for a
Sure.
moment, and I know it's a little bit awkward, and I apologize for being on remotely. But let's assume that we agree, and after we review the evidence, and I appreciate the fact that the Commonwealth has conceded that argument, that the manner in which this crime occurred does not fit the requirements for a conviction for an assault and battery with a dangerous weapon. The issue here seems to boil down to whether the judge convicted your client on a push to the door or a punch to the face, correct?
Your Honor, in regard to the Commonwealth conceding that the issue really was the push and not the punch. And I would submit to the court that it is accurate that the prosecutor, the trial prosecutor did in the transcript did argue that it was the push. So I would ask the court to accept those facts, that it was the push and not a punch. And that would, the issue of the punch was really only raised in regard to the discussion by the court in terms of its sentencing, in terms of its finding the defendant guilty. So that concern was raised for that particular issue. And I would submit that the only evidence of that was through a hearsay statement that was objected to.
Okay, so I appreciate your concession there. So now you claim that the charge of assault and battery on a household member shouldn't stand?
Your Honor, here's the issue that I see that in the basic point in regard to all of this. The assault and battery dangerous weapon, my client was sentenced to 2.5 years, the House of Correction, he served that sentence. In regard to the assault and battery on a household member, he was sentenced to 2 years probation from and after. In regard, both the assault and batteries, I would submit are the same, that it was one course of conduct. And if it is one course of conduct, I would submit to the court, then it is excessive punishment to punish my client twice for the same
The
act.
Commonwealth agrees,
Pardon me?
and the Commonwealth agrees.
It does, Your Honor. Therefore, the issue really boils down to a matter of sentencing. My client has already served in a 2.5-year sentence on an assault and battery. My concern is now he's facing on the assault and battery household member, he's facing 2 years of probation from and after. And having recently checked mass courts, I realized that my client actually has a pending now violation of probation that has been stayed pending the decision in regard to this court as to what will happen. I would submit to the court that it is not so much which charge, but in terms of the sentencing, because he has spent 2.5 years already.
Counsel, did you argue that to us in your brief?
I believe in my reply brief, I believe I raised that issue, I think I believe I did, talking about merging into the single act. I believe I put his sentence in both the brief and the reply brief, I believe. I was asking for it to be, maybe I did not raise it specifically as to what the course of action this court should take, but certainly
Because the only
asking
thing
it to
I
be.
noticed in your reply brief was one sentence on page 7, right before the conclusion of having served a committed sentence, the appellate submits he should not be punished twice for the same offense.
I'm sorry, Your Honor, I have a hard time hearing you. I apologize.
Let me speak up then. I only see on page 7 of your reply brief one sentence that says, in your argument about the single scheme and act or single act, that he's being punished twice. But I don't see any legal argument to support what you're claiming right now.
Your Honor, I believe when I talk about it in terms of even double jeopardy, I'm talking about the imposition of multiple punishments for the commission of a single crime. So
right,
I would.
That's why I'm looking for your citations to the case law and your legal argument. And I'm just want to be clear. I don't see it. And if you put it there and I'm missing it, I would appreciate you letting me know where it is, because I just have reviewed this pretty closely and I'm not finding it.
Well, my apologies, Your Honor. I had indicated, as I said, that in regard to using in excess what the legislature intended to be the punishment for a particular offense, unit of prosecution, legislature intended the Punishment Act for violation in regard to not having excessive penalties. And I believe Commonwealth versus Rollins, as well as the Marshall versus Commonwealth, I would submit to the court. I
just want to see where you're citing it to it in your briefs. That's all I was asking.
In the main part of the brief, as opposed to the reply brief, Your Honor? I'm sorry. I don't.
Either one, but that's okay. You can continue. Thank you.
Basically, the argument before this court is that I would submit to the court it is a single offense, and that my client should not be punished twice for that particular offense.
Would you be okay if we agreed with the Commonwealth? We vacated the ABDW. The only thing that remained was the conviction on the AB household and family member. And then, and then I suppose it would have to go back to the judge for resentencing. Would that be an appropriate resolution?
That would be, Your Honor. Yes. On that, I will rest. Thank you, Your Honor.
May I just ask one question? Do we need to accept the Commonwealth's concession about the basis for the the domestic A and B. Reading this record, can't we, I mean, do we look at what the judge could have concluded? And it's clear that he was admitting the hearsay statement about the punch based on this theory of an admission that wasn't denied. And why couldn't he have considered the punch as the basis for one of the offenses?
Well, then I would submit to the court that there was insufficient evidence based on that. Certainly, there is only a hearsay statement that was objected to in regard to coming in. I would.
But if it came in properly as an admission or as an accusation, I'm sorry, that wasn't denied, sort of like an adoptive admission, then why couldn't the judge have relied on it?
I would submit to the court that there was no further, if you will, evidence in regard to that particular act.
Does there has to be? Does there have to be?
I would submit to the court that in order to assess the credibility of that particular hearsay statement, that there should have been some additional indicia. And certainly you have the statement of a young child who is repeating a statement in regard to something that his mother said to him. And I would submit to the court that it was that the credibility in regard to this hearsay statement should be considered. And since there was
To weight, though, not sufficiency.
Your Honor, I would submit that the statement that being the only basis would not be sufficient in regard to to have the conviction. It was objected to. And I would submit to the court that although the court may say it goes to, it does not go to the admissibility, I would still submit to the court that the statement should not have been admitted because it was a hearsay statement, that it was not a statement that would come under an exception of the hearsay rules. And I would submit to the court based on that it should not have come in and therefore it should not have been the basis in terms of any conviction on either of the counts that were in which the court did find my client guilty. Any other questions? Thank you, Your Honors.
Thank you. We'll hear from the Commonwealth.
Morning, may it please the court. Excuse me, I don't know why my voice is doing that right now. Johanna Black on behalf of the Commonwealth. I'll just jump to where Your Honors seem to be leaning towards agreeing with the Commonwealth's concession that there wasn't sufficient evidence of use of the door or doorknob as a dangerous weapon. The Commonwealth will jump ahead.
Is it use or is it recklessness? I'm a little bit unclear.
So in the Commonwealth's brief, we analyzed it under both the intentional or the reckless prongs of ABDW. And the Commonwealth's position is that upon subsequent review of the evidence, it doesn't seem to rise to be sufficient under either prong. So with the reckless, it does appear from the case law that exists currently that there needs to be some sort of use of an object, whether it's a per se dangerous object or a not per se dangerous object, but that there has to be some use, and either it's intentionally used dangerously or it's recklessly or wantonly used dangerously.
Can I say I was confused by the statements on pages 12 and 13 of your brief. Page 12 says the Commonwealth did not have to prove the defendant intended to use the door as a dangerous weapon, citing the LaFebre case. Then on page 13, you recite some evidence that you say was not sufficient to prove the defendant intended to use the door as a dangerous weapon, citing the McDonald case. So if the Commonwealth doesn't have to prove that he intended to use it as a dangerous weapon, then why does it matter whether the evidence was sufficient to prove that he intended to use it as a dangerous weapon?
Right. So that was the Commonwealth just showing that its position was the evidence didn't rise to the intentional theory of ABDW. But with respect to the reckless, the Commonwealth also believes that there wasn't sufficient evidence that the defendant used or manipulated or had control of the doorknob in a way that would be described as wanton or reckless in the circumstances of the altercation that day.
So the sentence that on page 12 that Justice Sachs is referring to, in other words, the Commonwealth did not have to prove the defendant intended to use the door. That is in contrast to, you've switched to the reckless theories. That's in contrast to the intentional theory.
Right. The defendant could have used it recklessly. That would be another option for the Commonwealth to proceed under. However, the Commonwealth doesn't, looking at the evidence that came out at trial, doesn't think at this stage that it was sufficient. It unfortunately rose to what the Commonwealth believes were kind of equally inconsistent reasonable inferences. One being that, the push was hard enough that the defendant was at least wantonly using the door, but also it equally supports that the defendant just pushed Ms. Carey, and in doing so, because of the force, she turned, and that's how her head, and she fell, and that's how her head made contact with the doorknob. And the Commonwealth's understanding of the law is that if they're equally in conflict and they're equally supported by the evidence, one of the inferences wouldn't be sufficient.
Yeah, there might be
Commonwealth, I appreciate your concession on this matter, and I just want to focus on the issue. Didn't you get your pound of flesh? I mean, if we agree with you that when we review the facts that there was insufficient evidence to sustain a conviction on assault and battery with a dangerous weapon, that the push itself formed the basis of a straight assault and battery on a household member, he served 2.5 years in the House of Correction.
So you're asking me why this court should not vacate the ABDW conviction? I'm sorry, the assault and battery on a family or household.
While I appreciate the fact that the Commonwealth makes this major, makes this concession, out of fairness, given the facts of this case, this defendant ultimately served 2.5 years on a case that there's sufficient evidence on a push by the defendant of the victim, correct?
Correct.
Justice Walsh, if you could just remind, we can hear you, but it's hard. So if you just
Okay.
Yeah.
So
do I
guess
understand
I'm
that
just-
you're asking why we shouldn't just on appeal vacate the assault and battery on a family or household member conviction and hold the conviction as to assault and battery?
Yes,
Is that what you're getting at?
I am. Thank you.
No, it's fine. So for a number of reasons, one being that I don't think this court has enough record evidence or evidence in the record to make that decision. I think it needs to go back to the trial judge or the trial court for resentencing. For one, I know this court can take judicial notice of other dockets, and the defense did raise in their argument before this court today the fact that the defendant is facing a violation of probation hearing. If this court feels inclined and feels that it's appropriate to look at the docket, the Commonwealth's understanding is that the judge in the trial court who heard the defendant's motion to stay probation violation proceedings, currently the defendant's still being supervised on probation, but any violation is not going to be heard. It's stayed until this appeal is resolved. So there's that concern. The other concern is that if you vacate the assault and battery on a family or household member on appeal, you're essentially dictating a directed verdict by the trial judge. You're reducing where the Commonwealth's evidence was sufficient to prove that Ms. Carey was a family or household member. You're essentially entering a required finding of not guilty as to that element, which isn't appropriate. It's a charging decision by the Commonwealth. And additionally,
Commonwealth, let me just interrupt for a moment. It's probably from my 13 years in the trial court that I just have this underlying question of, I understand the appellate court may be the wrong place, but you could come before this court right now today and just say, I agree with my sister counsel. I've agreed that the assault and battery, the dangerous weapon, can't stand. And if we agree that the assault and battery on a household member, a finding of guilty and it being filed, justice has been done. What's the issue there?
So you're saying just enter a guilty filing for the assault and battery on a family or household member?
I mean, if you conceded that and you agreed to it.
So there are a number of concerns. So I think this is an attempt by the defendant, or it could be viewed as one, to avoid any possible conviction under the subsequent portion of assault and battery on a family or household member. Currently, because this is the first, my understanding, he was indicted as under subsection A of 13M, which is not a felony offense, but it does provide for up to 2.5 years in a house of correction and incarceration for up to 2.5 years in house of correction. So presumably the judge could have done the 2.5 years that he has served on the assault and battery on a family or household member conviction. Additionally, not to say that being on probation is not a sentence or isn't affecting the defendant's liberty, but it is significant, I think, that the defendant didn't ask to move to stay the appellate proceedings and ask for permission for the trial court to address any resentencing earlier. I'm not sure that the defendant would have been successful, where the trial court could have just waited for this court to resolve the issue on appeal of sufficiency of the evidence as to dangerous weapon. But I just don't think, Your Honors.
Right. Commonwealth, you may be correct. Procedurally, it may need to go back to the trial court if that's what we find. But if the Commonwealth was satisfied that even on an assault and battery with on a household member, a guilty finding enter in 2.5 years, direct time served, then that closed the case. It just seems that that would be an efficient administration of justice.
I'm not sure it's proper though. And that's something I would think the trial court could do as well. So
At the end of the day, when the result is going to be that when you get back to the court, that it's going to be the end of this prosecution, right? He's served his time, his probation is going to end, and there's not going to be any probation violation hearings, and it's right. I mean, at the end of the day, that's what's
I'm assuming, I saw in a motion to stay the probation violation proceedings that the defense told the trial court that the defendant's house of correction incarceration ended September of 2021. He's been on probation since. I don't know if I should be getting into why there's a violation of probation outstanding, but so
whether there's prosecution on that
right.
Separately, that's a different
Right.
matter.
I just don't know of, standing here today off the top of my head, a law that would allow, or case law that allows vacating the greater offense. And any argument that was made about that explicit issue was raised in the defendant's reply brief, which under 16C of the rules of appellate procedure is not appropriate. And this court doesn't hear that.
Right. I mean, your technical argument is that there's the DW part of the ABDW isn't proved. So it's just an AB.
Right.
And that's the same AB as the AB household and family. So they're duplicative. So you can only have the greater included,
Right.
Greater one. Yeah.
So if this court doesn't have any other questions, the Commonwealth will just rest on its brief.
Thank you.
Thank you.
Thank you both. Okay. We have two more cases in the courtroom today. We have one more that's going to be on Zoom after this, but we are not planning to take any breaks in between. So the next case is Robert Mahoney versus Town of Franklin and others, 22P164. And just before we get started, so I just want to, at council table for the appellees, we have Attorney Mayo and then not Attorney Barreau, but
Allison Prescricer.
okay. And it's going to be 10 minutes, 5 minutes? Okay, thank you. All right.
Thank you. Good morning, Your Honors. Annalisa Saldi on behalf of Robert Mahoney, the appellant. Your Honors, I believe the first issue in this case has to do with the statute of limitations and the notice issue related to that. And I believe the majority of this comes down to the timeline of what happened in this case. The appellant was, he was promoted to acting captain and then was demoted. And the day he was demoted, he filed his grievance with the union. It's the appellant's position that the union grievance process went on without his knowledge. He received no other information, which led him to file his complaint at MCAD. And where the dismissal comes up in this case is that the MCAD apparently reached their decision in the appeal in January of 2019. However, Mr. Mahoney did not receive notice of that decision until November of 2020. It's the appellee's argument that.
But he had notice of the underlying facts in 2016. Is there any law that you have to, that the case that the statute of limitations told while you wait for MCAD to?
Well, Your Honors, he was exhausting his administrative remedies before bringing it before the trial court, as he's required to do. And I don't think that he should be penalized for delays in the court process, delays as a result of COVID, and further the trial court as well. I mean, he needs to exhaust all of those remedies before he can take the next step. Otherwise, he would be prematurely bringing the case before the trial court.
He has to exhaust only on his 151B claim, doesn't he? And he doesn't have to exhaust the 151B remedy to pursue his intentional tort claims or his claims of contractual violation, whatever they may be.
My understanding is that he needs to exhaust it through the MCAD as well before bringing the claims. Otherwise, it would be a separate suit and a duplicative suit. So in the interest of, judicial economy, to bring it all into one final suit at the end of the administrative claims was the path he chose. The remaining issue has to do with the dismissal of the breach of contract claim.
Before you get there,
Yes.
okay, I understand what you're arguing with respect to the MCAD. I don't understand exactly your theory that the negotiations between the union and the town somehow affected your client's knowledge. Could you explain that?
Well, the negotiations were happening and he wasn't kept abreast of any of it. My understanding is that it was happening over email is how it appears to me based on the.
These were negotiations about that that somebody else should be promoted, right? So these would have occurred prior to 2016?
No, Your Honor, he was promoted in 2015, and then in 2016, it was apparently brought to the fire department's attention that the wrong person was promoted. But it's Mr. Mahoney's position that there was this short list situation where no one in the list order of priority had achieved a score high enough on the captain's exam. However, Mr. Mahoney had the highest score, and so he should have been the one to be promoted. When he was demoted, like I said, he went and filed a grievance with the union, and that was when I would say that the administrative remedies part of it began first with the union. And it's my understanding that they arrived to dismiss it with prejudice without involving Mr. Mahoney, without seeking his input, without him having counsel, without him, consenting to the dismissal.
So the unknown union negotiations had to do with the resolution in the MCAD of your client's claim.
No, I believe these happened before the MCAD.
Okay, so that's what I read. So it had to do with who gets promoted.
Correct.
Okay.
Yeah.
But so the ultimate result was that your client got demoted. I mean, whatever the reasons for that, he knew, he was on notice of it as soon as his demotion happened.
Well, that's correct, Your Honors. I mean, he was aware, of course, that he was demoted, but it was his understanding that he needed to go through all these other processes before he could bring it in the trial court. And it was not until 2020 that he felt that the administrative remedies had been exhausted when he got notice of the appeal decision in the MCAD.
Counsel, do you have any case law to support that argument that judicial economy would support tolling the statute of limitations for all other claims that are connected to a 151B claim?
No, Your Honor, that's my argument. It's not I don't have a case law cite for that.
Thank you.
Mhm, mhm. Now, with regard to the breach of contract claim, it's the appellant's position that the collective bargaining agreement is the employment contract. And I believe that's where some of the confusion arises as a part of the trial court's decision, where he acknowledges that the employment contract is the collective bargaining agreement, but then he writes in his decision that there's no link between the shortlist rule and the employment contract. But the shortlist rule, my understanding, comes from the CBA, which is how it would, that there's the nexus and why the breach of contract should survive.
So the contract claim is based on the collective bargaining agreement.
That's correct.
So wouldn't if there's an allegation that the employer has breached the collective bargaining agreement, doesn't that need to be raised through the grievance and arbitration process that's set forth in the contract?
Well, again, it was his understanding that it was going to be raised through the grievance process, but then the grievance process was dismissed with prejudice without his awareness. And he went forward with, again, I understand that MCAD did not handle the contract aspect of it.
You say the grievance and arbitration process was dismissed without his awareness. Was a grievance filed and then
Yes,
resolved adversely to him and the union didn't take it further?
Mr. Mahoney went the day he was notified of the demotion, he went to the union office to file his grievance. After that point, he didn't receive any further communications. It's my understanding that everything happened behind closed doors. I received some email communications at the beginning of this matter that showed negotiations between the town and the union. Mr. Mahoney was not copied on that. Mr. Mahoney didn't have counsel at that time. And he certainly wasn't aware that they were agreeing to dismiss his grievance with prejudice.
Is any of this alleged in the complaint? Dismissal of the collective bargaining agreement grievance?
I believe it is, Your Honors. I don't have the complaint in front of me, but I mean, that would be the breach of contract claim.
Counsel, did he actually file a grievance, or did he go to his union rep and communicate his disappointment? But did he actually file a grievance and then there was an actual denial of his grievance with prejudice on the contract claim?
So my understanding is he did actually file a grievance. He would have filed it on his own without counsel. And then from that point on, he didn't receive any communications regarding that grievance.
And where is that in the complaint? I know you said you didn't have the complaint in front of you, but you're here on an appeal of the dismissal of the complaint. So I'm hoping you know what's in the complaint.
I understand, Your Honors. Thinking back to it, if it's not in the facts of the complaint, it would certainly be in the breach of contract.
Your co-counsel or not co-counsel, opposing counsel throwing you a lifeline here.
Thank you. Thanks. I mean, do Your Honors want me to flip through the?
I think, yes, Justice Sachs would like to know where in the complaint. It's a short complaint. It mentions the grievance.
Oh, is it paragraphs 20 and 21 on record appendix 13?
Yes, Your Honors.
Thanks.
I would agree with that. And if Your Honors have no further questions, I would rest on the brief.
Mrs. Walsh? No? Okay, thank you.
Thank you, Your Honors.
So we'll hear first from the town, right?
May it please the court. Good morning, Your Honors. My name is Courtney Mayo, and I think it would probably be easier to tell you who I do not represent as far as the
Okay.
appellees, but Suffice to say, I represent the town of Franklin, its fire department, and its administration. You'll see, for example, Stephanie Lutz, who's not named in the complaint other than in the caption. She's HR. And we have the fire chief. We have 2 members of the select board, and Jeffrey Nutting was the town administrator at the time. He's retired now, but that's who I have. I have essentially the administration. And my sister is here on behalf of the union, but suffice to say that we both agree that the complaint was dismissed correctly by the trial court below for 2 reasons. One, of course, as my sister just talked about, 8 out of the 9 counts are time barred by the statute of limitations. And the other count, we don't believe states a claim for breach of contract. And as this court has really already addressed, we think in the 4 corners of the complaint, it's pretty clear the plaintiff admits that he knew of these things, these issues that he was having, because they happened to him directly. I know the discovery rule is being argued here, but when you look in the 4 corners of the complaint, the only thing that the appellant argues that he became aware of in 2020 is the fact that he was unsuccessful in the MCAD. And we don't think that is reason to apply the discovery rule here. All of these issues that he's addressing between being provisionally promoted to an acting captain, being essentially demoted, the collective bargaining agreement issue. And then he talks about the way he's treated by some of his colleagues in the fire department up to and including July of 2016. Those all happened to him personally. So he's aware of them. So the discovery rule wouldn't apply there. So based upon just the 4 corners of the complaint, we say that with respect to the discovery rule, what he's really talking about is in 2020, he learns he's unsuccessful at the MCAD. And that alone doesn't create a cause of action here. As 151B states, you are required to file your discrimination action and even probably the harassment piece of it in the commission within 300 days of the adverse action. But then the statute goes on to say 90 days thereafter, you can remove it and file it in the Superior Court. There's no tolling of the claim, and you don't have to wait until the commission reaches a decision. You can remove it anytime after that 90 days pendency in the commission. And so there was nothing preventing from.
So I mean, is the law then under 151B that basically at some point somebody who brings a complaint to MCAD has to make a choice? Like, I guess after 2 years, 360 days, 2 more years, at some point they have to make a choice. Am I going to stick entirely in MCAD or I'm going to go to Superior Court?
Yes, I think that's true, especially where, unfortunately for the commission right now, they're so overwhelmed with cases that it takes kind of a long time to get through that initial process. And I've had plenty of complainants and their counsels call me up and say, okay, look, it's been 2 years. I can't risk it. I've got to pull it and put it into the Superior Court. And that's often what happens. There are other cases that get handled so quickly that they have the opportunity to wait for that determination and still then file in the Superior Court. But yes, essentially, there's a period of time where you've got to kind of make that choice. Additionally, as this court has already asked, he could have filed a separate claim in the Superior Court for his other issues and then amended to bring in that 151B piece of it after the 90 days. So our position is.
And there's no claim splitting problem there because of the need to exhaust administrative remedies, is that?
No, not that I'm aware of, Your Honor. In fact, we've had it happen a couple of times in the past with other cases, in cases of discrimination and also in cases of Wage Act violations where you have to bring it to the Attorney General first. Whereas that complaint is then amended, everything kind of comes together and it's one case before the Superior Court. But that certainly was an option from our perspective in this case. But in the 4 corners of this complaint that's been filed, the last kind of adverse action, if we call it that, is dated July of 2016. And so we say filing the complaint in February, I believe it was 2021. That's just too far outside the statute of limitations for a timely claim here. The other piece of it that we're obviously maintaining was correct was the dismissal of the breach of contract action. And we say that according to what's pled in the complaint, the breach is allegedly a breach of the civil service statute. There's nothing from my reading of the complaint, I do have it here, that says we breached the collective bargaining agreement. In fact, interestingly enough, as I was writing this brief, and you might see it in my brief, I noticed in paragraph 31 of the complaint, the plaintiff seems to agree that we had to put in Mr. Baker as the appointment. You'll see I think if I flip to it really quick, I had it tabbed
In
here.
accordance with the provision of the CBA.
Correct. Yeah.
If the union brings a grievance on behalf of Mr. Mahoney and then settles it, is that a breach of the collective bargaining agreement?
We say no. That didn't happen here. And that's an interesting point that you addressed with the appellee, or excuse me, the appellant. There was no grievance for a breach of the collective bargaining agreement. And it doesn't state that as my reading of the complaint says. My reading of the complaint says in May of 2016, when he finds out that, oops, there's a mistake, we got to bring you back down to firefighter, paramedic. He goes to the Boston office of the union. That's what the complaint says. It doesn't say he sought out his union rep. It doesn't say, he filed step 1 of the grievance to his supervisor. It doesn't say he grieved. It says he went to the Boston office and kind of complained because he wasn't happy. There was no grievance with respect to a breach of the collective bargaining agreement. And you'll see that in even the brief we filed in the Worcester Superior Court, that he didn't exhaust his administrative remedies with respect to that issue. There was never a grievance on that issue on his behalf. The grievance filed was on behalf of Mr. Baker. And that's why Mr. Mahoney was not aware of it. Mr. Baker was supposed to be provisionally appointed pursuant to the collective bargaining agreement. And again, we're not talking about a full-time captain's position. The plaintiff was always entitled to have that position. He had to go through the civil service piece of it. And then if he was one of the top 3, he could potentially get that full-time position. What we're talking about is we had a short list and we need to just put somebody in as acting captain until we can fix that civil service issue. And so from our perspective, not only did we not breach the contract, but there's no claim in the 4 corners of the complaint that gives rise for a breach of contract claim. And additionally, we argued to the Superior Court, and you can see it in the brief, that if there was, he would have had to exhaust his administrative remedies and go all the way through the arbitration process.
And then it's not up to him to pursue a claim of breach, is it? Unless he's also claiming a breach of the duty of fair representation against the union?
Yes, I agree with you, Your Honor. I think he has to go to his union rep. They take up the torch for him, so to speak. They file the grievance on his behalf. But there's nothing here in the complaint that says that he did that. He went to the Boston, he didn't go to his local chapter. He went to the Boston, I guess, office and complained according to what's alleged in the complaint. There are no other questions.
Seeing none,
Okay.
thank you.
Thank you, Your Honor.
We'll give attorney for the union 5 minutes.
Hey, good morning. If it pleases the court, my name is Allison Presskreischer. I'm counsel for the union, IAFF Local 2637. And as not to waste this court's time, I think what we will say will entirely echo what my sister counsel has put forth before you. And so if there are additional questions, of course, I am more than happy to answer those. But if not, I think we'll rest at this time.
Nope, seeing none. Thank you. Thank you for coming. We'll, of course, take the case under advisement.
Thank you.
Thank you. So the last case in the courtroom today, as I said, there'll be one more on Zoom, is Elmore versus Elmore 22P 356. I saw Mr. Curran earlier. There he is.
Good morning. May it please the court, Dana Curhan for the wife. I want to start off by talking about the gatekeeper order. That was an order that precluded the parties from filing anything without permission of the court. Our first objection to that is that this was a temporary order that's expired in by its own terms in October of 2016.
If the parties complied with it for in 2017, 2018, 2019, right? I mean, without challenging it until the arguing on the motion to file the counterclaim, which the judge allowed.
The judge allowed the filing, but the judge continued to enforce, there was a specific objection to that it expired as of
But
its
no
own
harm
term.
there because that motion was allowed, you're permitted to file the counterclaim.
We were allowed to file that.
As far as I can tell, it seems the only thing that you were not permitted to file in terms of the filing of a motion was the motion to compel, but yet there was argument on the motion to quash, which was really the same thing, right?
Well, there were motions for discovery, there were motions to continue the trial. There were a variety of motions that we were not allowed to file.
But like the motions for discovery, was that disallowed? That was ultimately, even though there was this order, that was ultimately disallowed on the merits, right?
Well,
And actually, that's the motion to quash. The motion for discovery is the motion to quash.
I think it all goes hand in hand. I don't think it matters all that much which the grounds. Yes, we were denied the right to file probably most of what we wanted to file during the trial or attempted to file. I think there were discussions on the substance, and I have an issue with that. Just sticking to the gatekeeper for a minute. There are cases where the SJC said it's okay to impose a gatekeeper requirement if you have an abusive litigant. Usually we have a serial pro se litigant. There is, somebody says, look, enough is enough. There's no finding on the record here as to the reasons for the gatekeeper. There was nothing at the time that 2016 order issued. Maybe there was a hearing where there was some discussion, but in 2021, there was no need for a gatekeeper, and there was nothing. This order was entered by a different judge, and the current judge never said, here's why I think it's appropriate to continue this and to require that.
Did anyone ask?
I'm sorry?
Did anyone ask? Did anyone challenge? Did the wife challenge the gatekeeper order and say, Your Honor, there's no continuing basis for this, even if there was at some point in the past, please vacate it, so that the judge would have had an occasion to either vacate it or say, I think it's still justified because of X, Y, and Z?
There were hearings where there were objections made and discussions. So the answer to that is, I believe, yes.
Was a motion made to vacate the gatekeeper order?
There was not a motion that was called motion to vacate gatekeeper. There was an argument on on August, I believe it's August 21st. It was August 9th, 2021, the opposition to the motion to dismiss the counterclaim. So there was argument made there. And, if the judge had said, look, this party or that
Wait
party.
a second. So there was you point to a place in the transcript. I've got it highlighted on my thing here that with respect to the motion to file the counterclaim, there's an objection to there's a statement that the gatekeeper thing should be over. The judge says, then why did you file? Then why did you ask for permission? But is there anything besides that? Or is that the only time that there's any objection raised to it?
Off the top of my head, I know that there was some discussions, oral discussions on the record. I can't tell you right now where they are.
So we spent 5 minutes on whether the gatekeepers, and why don't we go to the merits of what you were not permitted to do? For example, how is the deposition of the husband's girlfriend going to lead to admissible evidence on his income? Are you even pressing the emancipation anymore?
Well, emancipation, I think is as to one child that was, I don't think we're pushing that here.
Okay. So then how is the deposition of the girlfriend going to help determine whether he's making commissions?
Well, for example, we believe that she was living in one of his rental properties rent-free. But, that is sort of one very small piece of a very large issue, which is we were denied all discovery. We weren't, the judge didn't just say, well, we think that that's abusive or we think that that's unnecessary. The judge said, no discovery is necessary. Now, here's the problem. The husband was working as a real estate broker. He sold approximately 35 properties with a value over the course of 2 years with a total value of $12.8 million.
Well, there's the 35 properties. There's an exhibit in evidence that over 2 years, about 16 properties, I think. I think you've proffered evidence that he was listing on more, right? I mean, I don't think there's not evidence that he sold 35 properties.
I think he sold 35 properties. I think if I'm wrong, the total is $12.8 million. It doesn't matter how many there are. His claim is that his net commission income is about 60-something dollars per week. Now, I think it's a fair.
I mean, and wasn't there in evidence a document from Coldwell Banker saying exactly what he got?
There is a document from Coldwell Banker listing his gross commissions. There are some deductions from that we were never permitted discovery of, and I think that really took it down. And I'm not taking what we got from Coldwell Banker as at face value. I think that was a printout of his commissions, and I'm not sure if it is from Coldwell Banker directly. I may be wrong about that.
Where is that in the record? And are you saying that the gross deductions would be more beneficial than what the judge actually considered? I'm sorry, not the gross commissions. Are you saying that if the judge had taken the gross commissions as his income, you would have done better than you did?
I think the gross commissions were probably, we contend that they were likely higher than what the husband provided in support of his financial statement. He seems to be very active as a real estate broker and very successful. And that really is the point. We should have discovery to determine how much his gross commissions are, how much he's deducting from that, whether those deductions are legitimate.
Well, I'm looking at record appendix in the exhibits, page 19, which is the Coldwell Banker Agent 1099 earnings detail. I see a total of 39,000. I don't see deductions on there. Is there something else we should be looking at?
Well, if you look at his financial statement, he is claiming to make something like $62 and change per week in commissions. It does not seem to add up here.
Well, 39,000 may be more than $62 a week. I think it would be.
$39,000 over the course of 2 years.
Okay.
And I counted 23 properties there, actually. So I was wrong by 16, but are there more than those 23?
I'm not sure. It may be 23, but I think the total, the gross sales.
So you're expert. There's somewhere in the motion for new trial, I think somewhere in this voluminous record, there is a proffer from an expert that says that she thinks his income is somewhere between 80 and 87,000 a year, right? Maybe it's not 27, maybe it's 87, but compared to the wife's earnings, is that a material change from when the alimony was ordered?
I think we should have a chance to show that, and not just have the judge say, well, he's a brand new real estate broker, he really doesn't make anything. There's nothing. Discretion. Discovery isn't discretionary. Discovery is something that we're entitled to as a matter of law under the rules and under case law from the SJC.
This is my concern, Mr. Curran. Suppose you're right, and I see what you're saying. You were not permitted to cross-examine, you'd have the full ability to cross-examine because of you were not able to fully get all this discovery. But so in the end of the day, though, suppose we do permit you to go, we say, you're right, go back, get discovery, spend tens of thousands of dollars in legal fees and dozens of hours of everybody's time. In the end, it comes out, well, she's making $1 million a year and he's making $87,000 a year. I don't see that as a material change. Is that worth it?
Well, I mean, I think that's something that we have we can evaluate ourselves, but only after getting the proper discovery, only after having experts testify to this. I mean, one of the experts was a CPA who would have said, based on the taxes he's paying, his income is significantly higher than he's stating on his financial statement.
Significantly higher, but higher enough to make out a change in circumstances.
I think so.
Her income had gone up.
I think so.
From 350 to, what is it, 935 in the interim?
I mean, I think
and his income, if you looked at his taxes, let's assume that he was even making twice what he claimed. Would that, in light of the increase in her income, would there be a material change in circumstances?
Well,
and the bottom line is what prejudice here?
Alimony,
we have to evaluate before we could afford any relief.
Unlike child support, alimony is based on need. And he is essentially claiming that, and the judge found that he is making negligible income. Essentially, at the original divorce trial, the judge imputed $27,000 in income to him. And the judge in this case said, well, he's actually making a little less than that. But I think her income is a little bit of a red herring. He gets equalizing payments for half the value of the business as of the time of the divorce. So I think the fact that her business is successful.
Is that an asset, or is that earnings, or is that assets? Is that asset division? You see what I'm saying?
That was part of the asset division.
So why isn't that separate from then the alimony and the earnings?
I mean, I think maybe her earnings are more part of this is what she makes from the asset, the half of the asset that she received, or at least some portion of it. Now, when you're looking at his needs, if he's making in the six figures, he may not need alimony. That's really our contention. But we were not allowed to call experts. We were not allowed to, and by the way, he did testify that the real estate market between 2019 and 2021 tanked, and it was terrible in 2021. So that's why I'm not making any money. And we noticed a third expert after his testimony who would have testified that the real estate market was pretty good up in 2021. So I think we had an opportunity to show that he made a substantial income, regardless of what her income is, that he made a substantial income and therefore had no need for $100,000 a year in alimony. So that's really our contention. And I think we were just denied the right to prepare and try our case in any manner. And we contend that was error.
Anything else?
Nothing else.
Okay, thank you. We'll hear from Attorney Jameson.
Good morning, and may it please the court. And I beg the court's forgiveness. I'm getting over a cold, so I'll try to speak up. My name is Peter Jameson. I represent the appellee James Elmore. At first review of my brother counsel's brief, it appears that what's being argued is that the gatekeeper order is the impetus for all bad things that happened to Ms. Elmore through the judgment issued by the Probate and Family Court in 2022. That is not the case. The gatekeeper order that was entered in 2016, to which both parties complied for 5 years, In spite of that gatekeeper order, Ms. Elmore was allowed to proceed with her counterclaim. The gatekeeper order did not prevent Ms. Elmore from obtaining discovery. Mr. Elmore's motion to quash, which was allowed, and his motion for protective order, that is what prevented Ms. Elmore from getting her discovery. And dare I say also the fact that Ms. Elmore served 8 deposition subpoenas, 26 interrogatories, and 61 requests for production of documents in an already 32-page long docket with, at that time, I believe about 600 docket entries. The gatekeeper order did not prevent Ms. Elmore from calling expert witnesses at trial. Her failure to adhere to the pretrial notice and order requiring her to disclose with a baseline level of information all witnesses she intended to call, her failure to do so in her pretrial memo, that is what prevented her from calling expert witnesses at
How do you
trial.
respond to the wife's, claim that the reason that I'm sorry for who's claim, but that the fact that he didn't submit the signed financial statement until late in the game sort of forgives not having said there should be expert testimony on it?
I don't believe there's a rule that requires a production of the financial statement on a modification of child support and alimony by a certain date after filing. If it was a divorce, then I believe supplemental rule 401 applies, which has a 45-day turnaround time or deadline. And even under this circumstance, he was still in a timely nature, if I'm not mistaken. But even still, what I believe needs to be pointed out and looked at is the difference in nature between the 2 complaints for modification which were filed. Mr. Elmore's complaint for modification was a child support modification on the basis that the 2 children who were subject to the child support order had emancipated. That's a relatively straightforward case in which you look at the facts and circumstances relative to those children and compare that to Chapter 208, Section 28, the definition of emancipation. Ms. Elmore's modification, as my brother counsel stated, was about alimony, which starts with a threshold discussion as to whether or not there has been a material and substantial change in circumstances, looking at the need of Mr. Elmore to receive alimony and the ability of Ms. Elmore to pay alimony. And there were multiple mile markers that by which the trial judge could look at the documents that she is supposed to review, the supplemental rule 401 financial statements, and the history of this case to say at a threshold, Ms. Elmore had not met that standard of demonstrating a material and substantial change in circumstance. That, of course, was the initial divorce judgment in which I was trial counsel, which the judge set a normalized income of $350,000 to Ms. Elmore and $27,000 attributed income to Mr. Elmore. So essentially, if Ms. Elmore comes to court on her signed financial statement and demonstrates that she is earning more than $350,000, which she clearly did in this case, then that is not a change in circumstances on her ability to pay. But what's interesting to note, and must be noted, is that there was in between the original divorce case and this case, another modification of alimony case in which both parties submitted financial statements at that time. That case did not go to judgment, but the parties were aware of each other's incomes. And the incomes are strikingly similar from, I believe it was 2018 to 2021. And I believe at least my client's financial statement is in the record appendix, if I'm not mistaken.
I'm sorry to harp back on this, but
Yes.
I found the part in the brief. It says in the appellant's brief that James's financial statement was due on June 12, 2021, but he did not provide a signed copy until 4 a.m. August 9th. What is that? Is there's some order that it was due on?
I'm not aware of any order that required him to produce. It might have been a demand, but I don't have that before me. But what is common practice, and I don't know if this was, I don't believe it was part of the motion to compel, but it was common practice is that at a pretrial conference, that is the point in which both parties exchange financial statements on a modification. In this case, it was, admittedly, it was on a short leash, and I think that was by design by the trial court. I believe Mr. Elmore filed in June, if I'm not mistaken. I believe Ms. Elmore filed her counterclaim, if I'm not mistaken, in July, and in this case went to a pretrial in August. And I believe that was by design by the trial court. because she wanted to keep this on a tight leash, as is her prerogative and her discretion as the guardian of the trial process.
And so your argument basically is that, you know, not basically. So the order about filing motions, that's sort of a red herring. It is the motion to quash was allowed. And the reason, I mean, so without any discovery, they do have to take your client's, you know, that 1-page Coldwell Banker summary and his financial statement at face value, right?
Well, it's a lot of face value to take because it wasn't prepared by my client and the judge gave credibility to it. There was no argument at trial that in some way or another, my client, Mr. Elmore, was in cahoots with Coldwell Banker to determine.
No, how about the financial statement though?
His financial statement, actually, the judge took exception to a lot of things on that financial statement. And my brother counsel was talking about business deductions relative to his gross income. The judge actually added that back in. So there was a level of scrutiny based upon my client's financial statement that the judge did not accept. So she did take an extra level and didn't take that on a face value basis in fashioning her judgment. She determined there's no material change in circumstances. Therefore, you don't get over that first prong, and therefore I don't change anything with regards to alimony.
But the material change in circumstances she was alleging didn't have to do with her income. It had to do with his income.
But the question becomes at that point, what is material? And I pardon me, Your Honors, I forget who raised it, but what if it was 50,000 was his income? That's still within the judge's purview as on a discretionary basis to say that's not material enough, especially when dealing with 935,000 on that side of the ledger. And also what is noteworthy is that on the judge's findings, I believe, if you permit me, the judge actually does a breakdown of Mr. Elmore's income. I believe it's page 5, paragraph 36. And Mr. Elmore, I believe, had claimed approximately about 150,000 in total income. Well, the bulk of that was alimony. The judge went through that and took that out. The judge went through and said, okay, and took testimony with regards to a capital gain income, which he utilized his assets to purchase. And then the judge also broke it down to say the rest is his earnings, which is far below what the trial court determined he could earn on an attributed basis. So she didn't lower or increase the alimony on the basis of him earning less money. She kept it at the same level. So I do believe the judge went through that exercise.
So the offer of proof for the CPA expert, Mr. Flaherty, was that based on the reported taxes the the husband was paying, his minimum annual income would be $174,000.
And it's strikingly similar to $150,000 because that's what he claimed on his financial statement for tax purposes. And that's with all of his streams of income coming into play. And actually the trial judge, kept out the expert witnesses because it was untimely, because it was midway through trial. And and we might be able to play what if, but if Ms. Elmore had announced at the beginning of trial, we plan on calling these expert witnesses. People do not just come up with an attribution of income theory overnight. It is something that has to be pled.
Well, this wasn't at least the CPA expert wasn't an attribution of income theory. As I understand it, was actual income based on the reported taxes. Now, whether that's accurate or not, I don't know, but.
Well, I think the trial judge, and reading between the lines, the trial judge repeatedly invited Ms. Elmore's counsel to cross-examine Mr. Elmore on his taxes. Now, you don't need an expert witness to provide the trial court what the tax codes are. The trial court can accept that as a matter of judicial notice and to reverse engineer that.
Is cross-examining him really a substitute for putting in expert evidence of what someone who reports this amount of tax payment should be earning in income?
Well, in this instance, where the proffered amount is $175,000, which is inclusive of alimony, it's inclusive of capital gain income, and it's inclusive of his earned income, and where Mr. Elmore is claiming $150,000, I think the trial court, as the guardian of the trial process, can say, I don't need to hear from this person. In fact, what is happening here is, again, the exact opposite of what we set out to do, which is, again, take a case that is based upon simply the primary issue being whether two children are emancipated. And again, as has been the course throughout this case in 32 pages of docket entries, exploded into something that is uncontrollable and actually takes away resources from other litigants who are waiting their turn to be heard.
How do you respond to the contention that we shouldn't consider the $950 million income because of the equalizing payments based on the value of the practice.
Yes, Your Honor. So we are getting a little bit into the dynamics of business valuation. But what essentially the court did, the trial court, which is appropriate in my mind, is to say, we will, as part of the normal, a capitalization of cash flow method to value a business, the trial court or the business valuator has to separate what's called personal goodwill from enterprise goodwill. Enterprise goodwill is, to borrow a phrase from Mr. Ron Popeil, the idea of setting it and forgetting it. This business will operate without my ongoing involvement. Whereas personal goodwill is what a business owner derives from their ongoing direct efforts to that business. And that was the major subject of the trial process at the divorce level as it relates to the finances. And the trial judge determined and went with Mr. Elmore's expert that the correct normalization income was $350,000, I believe, comparative to, I believe, Miss Elmore's number, which is around $565,000. And what that happened is
that is like a normal, like if she's not out of the practice, that's what a normal patent lawyer could make. But she's better than a normal patent lawyer, but we don't take that into account.
Right. It's sort of saying this is what this person would earn in a vacuum for this business, given a bunch of different factors. And if I may, it's sort of imagining that the end on one side of this equation is a number of, I believe it was 3 million, if I'm not mistaken, was the fair value of Ms. Elmore's patent law group. And on this side is a very, very long equation. And if you were to adjust any portion of this, you would end up at a different number over there. So you have to accept those two numbers together. Now, the point about Ms. Elmore's $935,000 in income is not that Mr. Elmore is seeking alimony on that basis, or that he would even have a fair chance of doing so. That's not what we're here for today. But what that does demonstrate, even though Ms. Elmore, the income above $350,000 is essentially what she bought as part of the asset division. She's buying the profits of that business. It still demonstrates that she has an ability to pay, which once again goes to the threshold issue of this case, where there was a material and substantial change in circumstances. And it should also be noted that very, very narrowly did Ms. Elmore avoid an allowance of Mr. Elmore's motion to dismiss. Very, very narrowly. And the case was still allowed to proceed. And still there was no material and substantial change in circumstances found on either of those two factors.
But counsel, and I agree with you that certainly the trial judge has the broad discretion to be able to control, and manage the caseload. But here, what do you say to counsel's argument that he wasn't even able to inquire? He gets a financial statement that looks wrong, right? That all of his kind of gut instinct and what people are telling him is that that's not right. Doesn't he have a right in discovery to at least depose some people, to set out some interrogatories to see if what your client signs under the pains and penalties of perjury is true versus let's wait and see at trial what really happened? I mean, I'm not looking at the trial so much as I'm looking at what he could have obtained had he been allowed, but for the gatekeeper order.
But again, respectfully, I disagree that it was the gatekeeper that prevented that from happening. The motion to quash prevented Ms. Elmore from getting that discovery. But what the trial court had in its disposal and had available them is what the trial court has in any number of cases before it, which is 2 signed supplemental Rule 401 financial statements, but with the added basis here of a document providing Mr. Elmore's total income, gross income, which the court adopted. It wasn't prepared by Mr. Elmore. It was prepared by Coldwell Banker. And there was no challenge as to whether or not that was improperly created or tabulated. And again, I do concede that this was on a relatively short leash in terms of the start of the action to the pretrial to trial, but it's all contained within the judge's discretion and the pretrial order that and the powers of the probate and family court at that level to make that determination.
I'm not disagreeing with that. I guess my point is that through this, it in essence didn't allow the wife to gather any evidence to use at trial.
And one of the things that we'll never know would be, what if Ms. Elmore, instead of serving 8 deposition subpoenas, including upon Mr. Elmore's girlfriend, And what if she had not served 61 requests for production of documents, but served a lean and mean 10 requests, tax returns going back 3 years, bank records going back 3 years. But that wasn't what was presented. In fact, what was presented was records going back, I believe, 5 years.
But does that justify the judge in denying all discovery versus saying, let's pare this down? I'll give you, tell me which 10 are really critical and I'll give you those.
At the time of the pretrial, it's within the judge's discretion in order to order it to a trial and say, you have essentially laid down the gauntlet to go after all of these things. And honest, I don't recall in the record whether there was a less intrusive means offered by Ms. Elmore at trial. I think it was, give it all to me or else, we have to continue trial. But if it was a pared down case, that's a different discussion.
Okay, well, thank you. The time's up, and thank you both. Again, a very interesting case. We'll take it under advisement. So that will conclude the in-court argument. At 11:45, we'll be on Zoom for the fifth case. And just, I want to thank the court officer, the clerk, and especially, if I can call you out, Mr. Carter, for getting this hybrid thing ready at the last moment, which worked out very well. So we'll be in recess.
Thank you, Your Honors.